All right, so welcome back to the Daily Facts, and we are going to do part two of Alexander Yuk Ching Ma. Yeah, we're going to get into his indictment. So, yeah, follow me on over there and let's get into it. All right, so we're back with this indictment. Let's get into it. So, we left off here. Pursuant to Executive Order 12958, signed on April 17th, 1995, as amended by Executive Order 13292 on March 25th, 2003, and Executive Order 13526 on December 29th, 2009, national security information is classified as top secret, secret, or confidential. National security information is information owned by, produced for, and under the control of the United States government that is classified as follows. So they're going to break down top secret, secret, or confidential. All right, so information is classified as top secret if the unauthorized disclosure of that information reasonably could be expected to cause exceptionally grave damage to the national security that the original classification authority is able to identify and describe. So that's top secret. I mean, that's huge. No one goes into this and says, oh, I want to reveal top secret, do they? I don't know. I'm thinking people do. All right. Information is classified as secret if the unauthorized disclosure of that information reasonably could be expected to cause serious damage to the national security that the original classification authority is able to identify and describe. So let's see what the difference is. All right. So this in top secrets, it's exceptionally grave damage. And this is serious damage. Secret is serious damage, and top secret is exceptionally grave. All right, let's move on to confidential. Information is classified as confidential if the unauthorized disclosure of that information reasonably could be expected to cause damage to the national security and that the original classification authority is able to identify and describe. Okay. And I would imagine at any time these could be interchangeable. I mean, something that you might think is confidential, it could blow up and end up being top secret. I mean, you just never know. All right. Access to national security information classified at any level can be further restricted through designation in SCI categories. Only individuals with the appropriate security clearance and additional SCI permissions can have authorized access to such classified national security information. Period. End of story. Full stop. Information classified at any level can be lawfully accessed by persons determined by an appropriate United States government official to be eligible for access to the classified information and have a need to know the classified information. Classified information should only be stored in an approved facility and container. Okay, it doesn't mean it's supposed to be stored on your laptop where somebody walking by while you're sitting in the coffee shop can just look at it. No, it shouldn't be stored there, and people shouldn't be opening it there. You just shouldn't have it stored anywhere except in a classified secret place, or whatever, however you want to define it, in a place that isn't, most people would not have access to except people that have access to that classified information. You follow me? So a room somewhere 50 feet underground. You get the idea. Security clearances, both MA. Now we're back to Ma and his accomplice, this 80-plus-year-old man. Both MA and CC1 working during their CIA careers in the East Asia and Pacific region. Both MA and CC1 held U.S. security clearances at the top secret SCI level and had access to broad range of highly sensitive classified material. Because MA and CC1 held security clearances, the U.S. government entrusted them with access to sensitive government materials, including classified documents and materials and information relating to the national defense that was closely held by the government. Period. Throughout their careers, as a prerequisite to their access to classified information, MA and CC1 signed several non-disclosure agreements. Okay, I mean, what else do we need, right? They signed non-disclosure. Non-disclosure means not disclosing information. Okay, so they signed several non-disclosure agreements in which they acknowledged both the harm that could result from the unauthorized disclosure of classified information and the applicability of criminal penalties should they make, in violation of their security oaths, disclosures of such information to persons not authorized to receive it. Okay, now we're going to go into the applicable law, the law that applies. Title 18, United States Code, Section 794A provides, whoever with intent or reason to believe that it is to be used to the injury of the United States or to the advantage of a foreign nation communicates, delivers, or transmits, or attempts to communicate, deliver, or transmit to any foreign government or to any representative, officer, agent, employee, subject, or citizen thereof, either directly or indirectly, any document, writing, code book, signal book, sketch, photograph, photographic negative, blueprint, plan, map, model, note, instrument, appliance, or information relating to the national defense shall be punished by death or by imprisonment for any term of years or for life. Did you get that? Punishable by death. Title 18, United States Code, Section 94C makes it a crime to conspire to violate Section 794A. Probable cause. Let's move on. The FBI's investigation has revealed that beginning at least by early 2001, former CIA officer Ma became a compromised asset of the MSS. The investigation has revealed that beginning on March 24, 2001, and continuing through March 26, 2001, Ma and former CIA officer CC1 conducted a series of meetings with at least 5 intelligence officials in a Hong Kong hotel room. During these meetings, Ma and CC1 disclosed a substantial amount of highly classified national defense information of the United States to the MSS officers. Now, again, like I've said before, and I'll say again, sometimes the United States could be setting these people up. So he could have been in a room with these with these intelligence officials in Hong Kong, and really they're working for the side of the United States, and they think they're disclosing classified information, but in fact, they're not, because the United States officials, government officials, caught this individual doing something. They caught it in time. And so maybe what they revealed, maybe they have in the past revealed sensitive information, but during the course of a sting, we'll say maybe. I don't know. I think that's a possibility, right? That they're really not revealing anything classified and confidential. You and I will never know that, but it's a possibility. Your Affion has reviewed both audio and video recordings of these March 2001 meetings, and the recordings have also been reviewed by appropriate officials within the CIA. Based on our collective review, it has been determined that during the 3 days of intensive questioning by MSS intelligence officials, MA and CC1 voluntarily and knowingly revealed U.S. classified information, including, but not limited to, the following subject matters. Okay, their CIA work experience and activities. Information concerning CIA international operations, including the cover used by CIA officers and CIA activities. cryptographic information used in classified and sensitive CIA communications and reports, information concerning the internal structure and organization of the CIA, information concerning CIA officer identities, information concerning CIA human assets, that's putting people's lives at risk, information concerning CIA use of operational tradecraft, information concerning CIA technical departments, information concerning CIA secure communication practices, and information concerning CIA staffing practices. Your affiant has reviewed a videotape of the March 26, 2001 meeting between Ma, CC1, and the MSS officers. Ma identified important aspects of the tape, such as location, people present, and topics discussed during an FBI undercover operation described later in this affidavit. The videotape and accompanying audio depict MSS officials paying Ma and CC1 $50,000 in U.S. currency, which counted while CC1 continued to provide classified information to the MSS officers attending the meeting. So your affiant has reviewed a videotape of the March 26, 2001 meeting between Ma, CC1, and the MSS officers. Ma identified important aspects of the tape, such as location. Your affiant has reviewed a videotape of the March 26, 2001 meeting. Your affiant has reviewed a videotape of the March 26, 2001 meeting between Ma, CC1, and the MSS officers. Ma identified important aspects of the tape, such as location, people present, and topics discussed during an FBI undercover operation described later in this affidavit. The videotape and accompanying audio depict MSS officials paying Ma and CC1 $50,000 in the U.S. currency, which Ma counted while CC1 continued to provide classified information to the MSS officers attending the meeting. So it's worth $50,000, you putting all of this at jeopardy. Following the March 2001 Hong Kong meetings, Ma continued to remain in contact with MSS officials and to work on their behalf. The investigation has revealed that as a mechanism to once again give himself access to U.S. government information, Ma applied for employment with the FBI. On December 26, 2002, Ma applied with the FBI for the position of special agent on or about December 30th, 2002, after being advised by the FBI that he did not meet the age requirement for the FBI special agent position. Ma submitted an online job application to the FBI for a contract linguist monitor tester position. On or about April 14, 2003, Ma submitted a written application for a contract linguist position in Chinese languages at the FBI Honolulu field office in Honolulu, Hawaii. On or about April 21, 2003, Ma used a prepaid calling card to call his MSS handlers to notify them of the status of his efforts to gain FBI employment. So now he wants to go over there and wreak havoc and sell secrets. On or about May 20th, 2004, Ma was identified that his background investigation for the contract linguist position was complete and that an employment contract would be ready for review in several weeks. Ma agreed to continue the hiring process. On or about August 10th, 2004, one day before reporting to work with the FBI, Ma telephoned a suspected accomplice and stated that he would be working for the other side. Huh, look at him. On or about August 11th, 2004, Ma reported to work with the FBI to begin employment and acknowledged with his signature on an FBI non-disclosure agreement his understanding of the secrecy requirement of his employment with the FBI, including secrecy concerning his FBI work, product, and materials provided to him. The non-disclosure agreement specifically cautioned him that federal laws, criminal laws prohibited the unlawful gathering and disclosure of such materials. In the non-disclosure agreement, Ma acknowledged, I understand the need for the secrecy agreement. Therefore, I agree that I will never divulge, publish, or reveal either by word or conduct or by other means of disclosure to any unauthorized recipient without official written authorization by the director of the FBI or his delegate. Any information from the investigatory files of the FBI or any information related to material contained in the files, or disclose any information or produce any material acquired as a part of the performance of my contract. Okay, we'll stop here and pick up next time. Thanks for stopping by the Daily Facts. Don't forget to like, share, subscribe, and leave a comment below. We'll talk again soon. Bye.